Good morning, ladies and gentlemen here in the room. Good morning to the people watching online, and good afternoon to the people who follow us in Europe. I'm Christiaan Weiland. I'm the Public Affairs Consultant for ILA in London based, and it's a pleasure for me to be here today, back in Washington. When 10 years ago, with ILA, we started to make the rounds in Europe, talking with companies, business associations, and policymakers that US-style litigation was being exported to Europe, and that litigation that followed from that was funded by litigation funders, we basically got a blank stare. Fast forward to 2022, and everybody is aware. There are new rules created across Europe that allow for US-style litigation. As Harold said this morning, there are more and more US plaintiff lawyers that set up shop in Europe, or they work through their offices here in the United States. But I think for me, a very good indicator of how the climate has changed over time is the number of US litigation funders, basically from all over the world. There are now over 60 in the UK, there are 40 in Germany, and almost 30 in the Netherlands. So with that picture of how Europe is changing, it's a great honor for me to introduce here the international panel of European lawyers, who are not only lawyers, but also litigators, who see firsthand the litigation in the trenches in Europe. And I would like to start with a question on what the panelists see in Europe as the trends in terms of legislation, in terms of litigation, but also in terms of what kind of cases are being litigated in Europe. And I would like to start with Jeroen Kortmann, who is partner at Stibbe law firm in Amsterdam, but also professor in European tort law at the University of Amsterdam. So Jeroen, maybe you would like to kick off.
Thank you, Christiaan, and thanks for having me. To describe the litigation trends in Europe, I think we just heard David Battista say how different areas in the US are. Of course, as you all realize, we've got 28, well, since Brexit, 27 member states, each with their own individual systems. So I think we're going to have to take a helicopter view and just describe one or two of the most general trends that we see. And I think the main one, and probably also the main subject for this panel, will be collective redress. So if you see how many different collective redress instruments have been introduced in Europe in different areas, geographically and legally, over the past few years, that is really what is driving litigation in Europe now. And within that, I personally think there are three trends, if you like, or perhaps it's a bit too strong to say they're trends because we're still at crossroads, and you see certain legislatures or judges taking a left, whereas in other countries they take a right on each of these issues. The three issues, to my mind, are firstly opt-out versus opt-in. The European legislature essentially allows member states to choose when it comes to collective redress between introducing opt-out mechanisms or opt-in. And we've seen over the past few years some jurisdictions, like the Dutch, like the Netherlands, where I come from and where I practice, introduce a horizontal opt-out system, very much inspired on the US model. Portugal, very well known with its opt-out system. That, of course, attracts a lot of large claims. The UK, with an opt-out for competition claims only. That means a lot of cases all of a sudden become competition cases, by the way. Whereas others go for opt-in. I think Martina will say something more on that. Second trend line that I see is, well, regardless of whether we allow opt-out or opt-in, who do we give standing to pursue these claims? Some countries like mine essentially don't regulate this at all, and that means we essentially see US firms setting up foundations in the Netherlands subject to no regulation at all, with funders in the background and simply running these cases, whereas other jurisdictions introduce regulation, sometimes even say you can only bring these claims if you have a state-issued license, which of course much more limits the scope for expansion there. And then the third trend line I see, a very important one, it was also mentioned in one of the earlier panels, is what is collective redress about? Is it about bringing compensation to individual victims of alleged wrongdoing, or is it about creating a deterrent for companies and actors generally? So is it about punishing, essentially? And there we also see trend lines. We're all eagerly awaiting a decision by the highest court in Europe on data breaches, so privacy breaches, where we've recently seen an advocate general say, there's a right to compensation for privacy breaches, but only if you've actually suffered harm. Well, fingers crossed, and let's hope that's the outcome before the court, because it's perfectly possible that the court says no, in order for there to be an effective remedy, it needs to be significant, and that may mean punitive damages. Of course, depending on how that plays out, it very much will influence to what extent data breach collective actions will be brought going forward in European jurisdictions. And I'll leave it with that for now.
Great, thanks very much, Jeroen. Turning to Germany, where the ink on a new legislative proposal is barely dry, so it would be interesting to hear from Martina Lind van Wijngaarden, who is partner at Freshfields law firm in Frankfurt, Germany, to hear how is the climate emerging there in terms of litigation, and also what are the implications of the legislative proposal. Martina.
Yeah, thank you, Christian, and thank you also for having me. The new proposal which is on the table is a result of the New Deal for consumers at a European level. And all the member states have been asked to implement laws which allow for collective redress, meaning actions for damage payments at a national level. In Germany, the Ministry of Justice drafted a law. The draft was leaked just a couple of weeks ago. It's supposed to be adapted by the end of this year, and then it's supposed to take effect as of June next year. You have to see this draft against the backdrop of 7 years of diesel emissions litigation in Germany, which really changed the litigation climate in Germany at a significant level. Claimant law firms have come up. There are 10,000s of individual cases, more than 100,000 individual cases, which have been in front of the German courts since 2015. The judiciary has been complaining that they have been totally clogged, that they need to be rescued. Shortly before the statute of limitation for alleged damage claims against Volkswagen was to expire, in 2018, the German legislator created a new law. You might call it a Lex Volkswagen, because it entitled a consumer association to bring an action for declaratory relief only on common questions of law and fact, which then, that was the idea of that act, would entitle individual consumers based on the declaratory judgment to go after the company. The umbrella organization in Germany responsible for dealing with consumer issues brought such an action. The case was settled in 2019. More than around 250,000 consumers received a compensation payment. And against this backdrop now, the draft has been created. Like the model action for declaratory judgment, it provides for a consumer association which has standing. This consumer association then can bring a claim on behalf of consumers and small entities. These consumers and small entities have to register their claims with the Federal Register run by the Ministry of Justice. They can do this, according to the draft, until the day before the first hearing in this case. The process for the proceedings is as follows. The court first renders a judgment on liability. If it finds that there is liability, it will set out how the individual damage amount is calculated. Then there's a mandatory settlement phase. If parties cannot agree to settle, in brackets, I think they will always settle, brackets closed, there will be a final stage where the court will render an aggregate damage judgment. According to the reasoning of the draft, the court can estimate the aggregate damage amount. How will it do this? It will look at the numbers of consumers and small entities who registered their claims. That's one factor. And then the second factor is that they will just estimate what's the average damage amount per person. And according to the draft, they can they can estimate at the higher end. The creators of this law were really worried that the aggregate damage amount might be too small. So they can really aim high. This is it in a nutshell. But the law doesn't mean that thousands of individual cases will go away. They will stay because the plaintiff bar will always find a way to have parallel cases to earn money, fees, just by bringing individual cases. The US plaintiff law firms will continue to collect cases or claims to bring collective claims. And then there will be this third kind of action, the collective action brought by consumer associations. So basically, this means for companies doing business in Europe, if you are dealing with a lot of consumers, if you are dealing with small entities, the litigation environment will be much more hostile.
Thank you very much, Martina. Turning to the United Kingdom, to Kenny Henderson, who is partner at CMS law firm in London. Kenny, a lot of things happening. The country with the most funders in Europe, a lot of cases, multi-billion dollar cases, multi-billion pound cases, I should say. So can you give us a flavor of what's going on the litigation front in the UK?
Yeah, of course, Christiaan, and thank you to the ILR for inviting me to this important event. So just to canter through what's happening in the UK, focusing on collective redress, the UK has a number of procedural mechanisms for bringing claims. Traditionally, like much of Europe, we've been used opt-in mechanisms requiring an election, a choice. A mass tort, somebody has to choose to join a claim, and they've focused around product liability, pharmaceutical, health tech companies have faced a lot of those claims. Those are not new. But we do have two opt-out mechanisms. One of them is called the representative action mechanism. We've had that for hundreds of years. It's been rarely used. We've had it for hundreds of years, and it's actually the progenitor of the US class action mechanism. So I'm afraid that was our fault. What you did with it is not our fault, but we did create that concept. And then we also have, since 2015, a statute for bringing class actions solely for antitrust claims. So again, unlike FRCP Rule 23, it's not for a variety, a broad range of substantive claims. It's solely focused on antitrust. And I'm going to speak a little bit about that because it's worth digging into that and what that has done to the UK. So if I could bring up slides, please, to show, and I'll just talk you through this briefly because we can talk at high level, but data tells you what's happening. So hopefully that is sufficiently large to be legible, but I'll speak through it. So remember, this law was introduced in 2015. The top half of the slide is cumulative number of people in UK competition class actions. So we're seeing numbers increasing, and the little people are consumers. They represent consumers, and the little, supposed to be a factory, are non-consumers brought in class actions. This is not a device solely for for consumer claims. And you'll see from 2020 onwards a real spike, a real increase. That is because in December 2020, our Supreme Court handed down judgment in a case called Merrick's and MasterCard, which some of you may have heard of. That was the first proper evaluation by our highest court as to what the certification standards should be and should be applied. Our certification standards look at the proposed representative. They look at a commonality test. It's not the same as the US. We don't have common issues don't need to predominate over individual issues, but there still is a commonality test. And they also look at the suitability of that case for our mechanism, for this mechanism. And the Supreme Court, in a split decision, decided that suitability is a relative test. Is it more suitable for this proposed group to proceed as a class action or as individual claims? And the minority view from the judiciary there in that judgment, who were outvoted, they were very concerned by that. They said that would denude it because that's the purpose of group proceedings. It is more efficient, so it's hard to imagine. There won't be that many claims, proposed claims, that are more suitable to proceed individually. So we have a low certification threshold. We don't have a rigorous analysis, ways of looking at the certification case that you do in the US. And that led to this spike, 100 million people going from 70 in 2010 to 170 in 2021. And we're not through 2022 yet, but you can see the trend there. Because with that low certification threshold, the funders had confidence to fund these other cases. And then just speaking briefly, the graphic in the bottom left is only for showing 2022, but which sectors are facing these claims? For now, it's predominantly tech, but that will expand in the future. And the bottom right is the actual number of claims increasing. Again, you can see from 2020 a real spike. But also what I think is interesting there is the pale turquoise-ish blue is of standalone claims. The darker color is of follow-on claims, follow-on claims relying on regulatory infringements. What we're really seeing now is these kind of creative claims being brought ahead of regulatory conduct. That's a different experience for in-house counsel. That is moving ahead of the regulators. And who's bringing these claims? It's mainly US plaintiff firms, particularly Hausfeld, Scott & Scott to an extent as well. But it's not exclusively the US plaintiff firms, but it's mainly them. So there is a lot going on in the UK. Antitrust class actions is the hottest thing right now, but we're going to see more coming through beyond that.
Thank you very much, Kenny. Well, let's move on to when I worked in-house at Time Warner and Philips. Our CEOs and CFOs were predominantly interested in my lobby work. What is the bottom line impact? So let's turn maybe to the bottom line impact of litigation and focus on damages. Are there introduction of punitive damages? And also what about the issue of undistributed damages? And maybe starting with Martina for this round, you already talked a bit about how the damages are established. Do you see a sort of introduction of punitive damages in Germany, and also on the issue of undistributed damages? How would that work in view of the fact that it's basically an opt-in system, that Germany wants to introduce?
Yeah. So as to punitive damages, this new law I was talking about is mainly on procedural issues. It does not tackle punitive damages. That's a question of substantive law, and basically punitive damages in Germany don't exist. As to undistributed damages, the good news is that once the court has estimated the high aggregate amount, this amount is given to a trustee who is supposed to distribute the money. He, the trustee, an accountant, a law firm, is supposed to check the entitlement of each individual claimant and to assess what's the right amount according to the formula set out in the liability judgment. If something is left over, if the damages are not entirely distributed, then this amount is supposed to be refunded to the company. But what does this mean in practice? I think there's a super high risk that the aggregate amount will be estimated too highly. Why is this? Because there will be claimants or consumers who sign up for the class action who do not have a valid claim. The Volkswagen example is telling. I mentioned this declaratory model action. More than 400,000 people signed up. The case was settled. Only 250,000 had a valid claim. And this will happen over and over again. So then this trustee comes in. Supposedly he must be independent. It will be a money-generating machine for accountants, for other law firms, who then will take years and years to distribute the money, to test the cases, etc. The company doesn't have any say in how they distribute the money and in how long it takes. So even if at the very end there are undistributed funds, it will take basically forever. And from a company's perspective, the cash is out once you had to advance the entire aggregate damage amount to the trustee. Therefore, at least, I must admit it's better than no refund. But if there is some room to maneuver and to influence this draft law, I think that's a place where the focus should be on.
Very interesting. Undistributed damages going back to companies. Well, I think CEOs and CFOs will be jumping up in the air if that would happen. Kenny, maybe turning to you on the question of damages, particularly in, for instance, data protection cases, which we have seen quite significantly in the What is the obstacle currently in these cases to pursue in assessing the damages? You know, because that seems to be a major issue in litigation, in the Mastercard case, in Lloyds versus Google.
I would like to follow up on a theme from Martina was saying about undistributed damages, because I think it demonstrates a point made in an earlier panel about the challenge that the legislatures face in this, that they don't live and breathe these cases the way we do. And just little changes in procedure, in sentences, in rules, make an enormous impact on incentives. So in our antitrust collective redress law now, you know, you really get a lot of undistributed damages where you have opt-out mechanisms. You've got nearly 260 million people in the UK in antitrust litigation in a country with a population of 70 million. How is that possible? It's because many of us are in multiple antitrust class actions that we never asked to be in, we don't know we're in. So what's going to be done, you know, if these matters do proceed and either settle or go to trial? Well, our laws, and just demonstrating the point about how the nuance of the law and the procedure impacts, our antitrust law, how it deals with undistributed damages, is that if you go to trial and there's an award of damages, the funders are paid out of the undistributed sum, so the class members, are those that participate in the distribution, are made whole, and none of the undistributed damages revert to the company. They go to a charity, the Access to Justice Foundation, which is very laudable, and they'll get millions of pounds. If there's a settlement, the rules provide that as long as it's fair and equitable, elements of the undistributed damages can revert to the defendant. Now, what is a company going to do in that position? You know, that's a big call. You know, you know that millions of pounds are going to be undistributed, so there's a huge amount of settlement pressure. We don't have settlement sticks like treble damages and no contribution. You know, in the US you've got huge settlement sticks, but we've got a massive settlement carrot. And so the settlement pressure is non-correlated to merits, which is, I think, is bad policy. And that's not intended. That was not intended by the legislature, to impose that enormous settlement pressure on companies, irrespective of merits. But that's where we've ended up.
Fascinating, how it's different in each jurisdiction. Turning to the Netherlands, Jeroen, what do you see there in terms of damages for material compensation, immaterial damages? You see a bit in the data GDPR where it's allowed.
Well, if you don't mind, Christiaan, I'll answer the question from the broader European perspective. So I think as a word of warning to our audience, who I assume are mostly from America, even if some are tuned in from Europe, you'll hear from many European practitioners that punitive damages don't exist in their jurisdiction, which is true for the Netherlands. But if you zoom in and you look at the types of damages that are available, like immaterial damages for the mere fact that a privacy right has been breached, and you give that into the hands of litigants plus judges, who sometimes, of course, want to see their judgments have effect, then while they're being framed in judgments as awards for immaterial loss, there is a clear undertone that the overall award needs to be deterrent, and therefore you're essentially back at something that looks like punishment. Likewise, you know, many of the European monetary judgments include a very, very high element of statutory interest. In many of the national systems, you have a right to statutory interest from the moment the loss was suffered. Well, if you take a large antitrust case and a cartel has taken place, the enforcers have investigated and pursued it, by the time it reaches the civil courts in damage cases, the damages that have accrued themselves are lower than the interest sum that accrues on top of it. And actually, if you zoom in on the national rules on statutory interest, there's often a punitive element in it because they were written for contractual context. And in a contractual context, the idea was, you know, you owe a sum of money, and if you don't pay, the interest should be a bit punitive so as to punish you for late payment under a contract. But if you apply those same rules to a tort debt, as many jurisdictions do, going back 20 years, many of the cases, the overall sum is actually mostly interest with a clear punitive undertone in it. So, you know, is it punitive damages? Technically, no. In terms of effect, yes. And then to the undistributed damages, I mean, the honest answer is we don't know. In the Netherlands, we've got the new opt-out collective regime, as I said, and it clearly leaves room for judges to allocate on a, well, with an American-French term, on a cypre or cypre basis, which of course the Americans have borrowed through English law from French medieval law, doctrine and trust law, and then, you know, in the hands of American litigation lawyers, most of the plaintiffs, it becomes something very interesting in the collective redress context. We don't know whether judges are going to be tempted to allocate undistributed damages to charities, as the rule says in England. I personally suspect that will definitely happen on a regular basis, because there is, again, an undertone also with judges of saying, if we found defendants liable and we see not enough of the alleged victims coming forward to collect, the notion of letting the amount of money revert to the wrongdoer, so the defendant who's been found guilty of wrongdoing, will be too counterintuitive. So I suspect that judges will actually use that. But our system has only been in place since 2020, and we haven't reached judgments of that kind yet.
And the report on this issue from the Ministry of Justice on undistributed damages, which we expect any time, is not yet out, I think.
Well, yeah, that is policy making of the higher kind. That's what our legislature does quite often. It introduces a new instrument. So in 2020, since 2020, we have an opt-out collective action regime. And immediately afterwards, they start issuing instructions to universities to prepare reports on what the impact is. There's no way, anybody who understands legal practice knows, there's no way you can reliably set out what the impact of any piece of legislation of this kind is until you're 5 to 10 years from the moment of introduction. Yeah. So here we will get, and you know better than I do, Christiaan, but we'll get a report from essentially a university-type institute in conjunction with the University of Rotterdam, who will report on what to do with undistributed damages in a factual situation in which we've never even encountered a judgment yet for damages, right, let alone come to the moment where they have not been distributed yet. So we've never reached that yet. Frankly, I think it's crazy that we have that report coming up already, and I don't know what the outcome will be, but I strongly suspect it will be inspired by lobbyists from this great country, as many of these cases are.
On that happy note, let's turn to the audience for questions. Are there any questions from the audience here in the room? This gentleman here.
Third-party litigation funding in Europe, and the Chamber or the ILR just published a report talking about the national security implications of this kind of funding. And I'm curious about whether you all have looked at, or organizations in Europe have looked at, the sources of that money and similar implications about how the lawsuits are motivated, or the funders are motivated in Europe.
Who would like to take that question? Because the problem in Europe, of course, is that we don't have disclosure of funding agreements. There's one rule in the Netherlands, for example, that we just say who the source is of litigation funding, but where the money comes from, I don't know.
Yeah, but again, Christiaan, these cases are now developing, right? So I'm currently defending 2 large class actions in the Netherlands. It's Dieselgate against Mercedes-Benz and the App Store case against Apple. And both of those cases involve various foundations created by mostly American plaintiff firms, like Kenny mentioned Scott & Scott and Haasveld, but actually also personal injury lawyers from Tennessee, who are now running Dieselgate cases in the Netherlands, after, by the way, flying in on private jets, and then you complain about exhaust gases, but whatever, nice and interesting. And they are running those cases, and as defense counsel, of course, we will be pressing our judges for disclosure of the underlying funding arrangements, but whether the judges will be receptive towards it and to what extent remains to be seen. So I think personally it's too early to say, we have no regulation, but judges have significant power. They are kind of the gatekeepers here. Yeah. And it's for us as defense counsel to persuade them to be stern there and strict, and to have plaintiffs open up about the underlying structures.
Interesting. Kenny and Martina, anything to add, or shall we turn to another question? Or?
Yeah, maybe just one addition on this new law. It provides that a claim can be dismissed if the funder has undue influence on the strategy of the claimant consumer association. And they have to disclose the funding arrangements if the defendant can demonstrate that there is cause to believe that there's this kind of undue pressure. So hopefully in the future we will see more of these funding arrangements, and then also hopefully some of these cases are dismissed on that basis.
I had just one observation on funding. So in the UK, we have really quite robust adverse cost rules, and we have them in Europe, but they're often in Europe, they're capped. They have adverse cost rules, but they can be capped at quite low levels, which I don't think financially is a disincentive for very high value cases. In the UK, they're uncapped. So the loser, claimant or defendant, would have to pay usually between 60 to 80% of the other side's legal costs, which in these cases can be very significant. and funders are cognizant of that. So commercially motivated funders do look at merits. They do look, and somebody with a different motivation, national security, would be unconcerned. That's priced into what they're doing. But when we don't have regulation around this area, we don't look at the source of funding. You know, they're in offshore jurisdictions frequently. And I do think that's an issue certainly for consumer-funded claims, where consumers are protected in other transactions, buying insurance, dealing with commercial banks, etc. We don't have regulation there.
Unfortunately, we're out of time, and I would like to thank the international panel very much for their contributions here and flying all the way in from Europe. A big hand for the international panel. Thank you.